Hello and welcome. You're watching To The Point. As the BJP-PDP government completes 2 months in office, how satisfied is the PDP with the alliance? And how does it look back on the many problems that have hit the government and the alliance? Those are the two key issues I should explore in part 2 with the President of the People's Democratic Party, Mehbooba Mufti. But first, the Chief Justice of India's refusal to participate in a meeting to set up the National Judicial Appointments Commission has created a unique and intriguing problem. Not only has it stymied the Commission and therefore stalled the appointment of judges, it's also placed the Chief Justice arguably at odds with his own Supreme Court. So has the Chief Justice acted unconstitutionally as the Attorney General has claimed, or is his behaviour justifiable and warranted? That's the subject in part 1. And joining me now to discuss the unique and intriguing situation created by the Chief Justice are two of India's foremost Supreme Court lawyers, C. Sundaram and Dushyant Dave. I'm also joined by a former member of Mr. Modi's government in Gujarat, Jay Narayan Vyas. Mr. Sundaram, Parliament has passed a constitutional amendment creating a National Judicial Appointments Commission, and it's been ratified by 20 states. Secondly, Parliament has also enacted the NJAC Act. Now, although these are under challenge, they've not been stayed by the Supreme Court. So is the Chief Justice right in refusing to participate in a meeting to appoint two eminent persons to the NJAC, or has he behaved unconstitutionally, as the Attorney General has claimed?
I do believe that it's a matter which has a lot of grey in it. I certainly would not classify it as unconstitutional. We cannot lose sight of the fact that there is a day-to-day hearing going on about the very constitutionality of this NJAC and of the enactments following it. And the Supreme Court has made clear that they intend to conclude hearings within the next couple of weeks and hopefully deliver judgment soon after. This is really a very piquant situation here, because what does happen should the Supreme Court 2 weeks from today or 3 weeks from today decide that the entire amendments were unconstitutional, that the subsequent act also is bad, then what happens to anything done in the meantime? Now, I can fully appreciate the fact that when a case is going to be heard after a period of 6 months or something like that, and there is a long interregnum, that something has to be done in that interregnum, which is why usually the court does pass directions. On the one hand, yes, there is no stay against the constitutional amendment. But on the other hand, there's a day-to-day hearing which is going to culminate in 15 days. And I keep wondering why. If something could have waited this long, it could not have waited 2 more weeks before all these meetings were called for.
Well, actually, let me answer that for you. Forgive me, let me answer that for you. No, let me answer that, Mr. Sundaram. I'm interrupting you because I can answer that question you raised. Your question was, when things have waited 2 weeks, why could things have not waited another 2 or 3 weeks before the meetings were called? The reason is that on Friday, the bench hearing the NJAC actually specifically asked the government to constitute the NJAC, and I'm quoting, as early as possible for the limited purpose of considering extensions for the tenure of additional judges of various high courts. So the government has actually acted at the behest of that bench. That's the answer to your question.
In fact,
now the Supreme Court Chief Justice has contradicted his own bench.
It's very good that you asked that question, because at the same time the Constitution bench also said that new appointments can wait. At the same time, the Constitution bench felt that new appointments can wait.
But new appointments weren't happening, Mr. Sundaram.
NJAC will be
Mr.
nothing.
Sundaram, forgive me, I'm interrupting again. Please. New appointments were not going to happen. This was being asked for to go to the bench as soon as possible.
And they were not going to happen. That is the point.
No, forgive me. It's not new appointments.
Right.
I'm sorry, Mr. Sundaram. I'm interrupting you because you're factually wrong. It's correct that we should actually not be factually wrong. The Supreme Court bench asked the government on Friday to constitute the NJAC as soon as possible for the limited purpose of making permanent extensions for additional judges. That was the purpose. No one was going to make new appointments. Now, the Supreme Court Chief Justice has contradicted his own bench. That's the second bizarre element of this drama.
Karan, all that I was pointing out was that the formation of this NJAC was asked to be for a very limited purpose. It was not being asked to
Quite
be
right,
for
and even that
purpose
limited
including
purpose has been
appointing of
squashed by
new
the Chief
judges.
Justice.
And
Let me
I
bring
think
in
I think you and I are on the same page there.
No, we're
It
not.
is very clear
No, we're
that
not.
it
No,
was
we're
only
not.
for a
No, we're
limited
not. I'm
purpose
contradicting
that it
you.
was being constituted.
No, we're not on the
And
same
I
page.
believe
Forgive me.
that
I'm contradicting
in such
you. I'm contradicting you. Let me bring in Dushyant Dave. You are absolutely clear, Mr. Sundaram, that this is not unconstitutional behavior as the Attorney General has alleged. Secondly, you said that in fact if the formation of the NJAC could have waited 2-3 weeks, it could have waited 2-3 weeks more. You're overlooking fact that the Supreme Court actually wanted it constituted as early as possible for a specific limited purpose. I want to bring in Dushyant Dave, who I believe has a very different opposite view. Dushyant Dave, the Chief Justice's oath of office says, and I'm quoting, "I will bear true faith and allegiance to the Constitution of India as by law established." Now, by refusing to help set up a constitutional body, has the Chief Justice breached his oath of office, or do the words "as by law established" mean that he can question the legal validity of the constitutional amendment setting up the NJAC, and therefore he hasn't breached his oath of office? Which is it, Dushyant Dave?
There is something more to that oath, Karan. He also says in the end, when he takes the oath, that I will uphold the Constitution and the laws. Now, both the Constitutional 99th Amendment Act as also the NJAC Act are now in operation, and everybody in the country, including the Chief Justice of India, is bound by that. To my mind, I think Chief Justice has not been well advised to write that letter and not to join the NJAC for selecting the eminent persons. I personally feel that it is a very extremely unfortunate situation. I mean, it's really surprising that person of as high a stature and a constitutional person like the Chief Justice of India should have really said that he would not abide either by the Constitution or not follow the NJAC Act. To my mind, it's both unconstitutional on his part to do so, and it's really not upholding the laws on his part. So it is an extremely sad commentary on the part of the Office of the Chief Justice of India. I really wish he was better advised, and I really wish he had done much more introspection than what he has done.
Dushyant Dave, I want to raise with you a second dimension of the Chief Justice's decision. On Friday, that's literally just 4 days ago, the Supreme Court bench hearing the challenge to the NJAC asked the government to constitute the NJAC, and I'm quoting, as early as possible, but it was for the limited purpose of considering the extension of tenure of existing additional judges of various high courts. Now, the CJI's refusal not only undermines that direction, it actually makes a mockery of the Supreme Court's instructions to the government, doesn't it?
Well, you know, you have to look at it in many ways. For example, the Supreme Court has not stayed the implementation of the Constitutional Amendment or the NJAC Act. Had the Supreme Court done so, the Chief Justice would have been absolutely justified in refusing to participate. But Supreme Court not having done so, the act of the Chief Justice in refusing to participate virtually amounts to a stay on the administrative side. So really it's an extremely peculiar situation. That apart, Section 4 of the NJAC Act really obliges the government to get the, all the pending vacancies within 30 days and refer them to the Commission. So these are mandatory provisions, and Chief Justice should have known that these mandatory provisions have to be complied with.
Absolutely.
So I definitely feel that Chief Justice is really, I would say, on a wrong side of the page.
Let me very quickly bring you in, Mr. Jainarayan Vyas. Whatever the rights and wrongs of Justice Dattu's action may be, I want to put two other things to you. Firstly, do you accept that he's brought the process of setting up the National Judicial Appointments Commission to a grinding halt? And secondly, if the commission can't be set up, it can't function. Meanwhile, the collegium system has ceased to exist, so judges hereafter cannot be appointed. So now the government has two problems. Setting up the NJAC has come to a grinding halt, and judges can't be appointed, and these existing additional judges whose tenure needs to be extended now can't be extended.
Karan, there are two or three things. I think I would totally agree with my learned friend, Mr. Dushyant Dave. See, basically, it is a law which is on the statute book. Now, you can either change it, you can either amend it, or it can be suspended for the time being through a legal process. None of this having been done, I don't think it is proper on the part of the Chief Justice, who is primarily a custodian and a protector of law, to have done this, number one. Number two, I was imagining for a while that supposing Supreme Court bench would have given this directive to an individual or a government, and the government or an individual would have defied this, it would have been taken as a contempt of the court. Chief Secretary doing it, Chief Justice doing it as if it is nothing. So I
quite right. You're suggesting, Mr. Vyas, I'm interrupting you. You're suggesting that the Chief Justice's refusal to participate in the setting up of a constitutional body which has not been stayed and therefore is constitutionally valid is actually defiance of the Constitution. That's what you're saying, aren't you, Mr. Vyas? A quick yes or no?
Yes. Apart from that, third point, Karan, is that, you know, this is even though limited purpose, it was a kind of requirement as provided by the Act in force. So whether it was for a limited purpose or whether it was for a full term,
true.
You know, you can't differentiate that this was for a limited purpose. And fourth, what would happen to those judges whose terms are required to be extended?
They are the ones who are going to suffer. Let me bring in Mr. R.M.S. Sundaram. Mr. R.M.S. Sundaram, I want to go back not to the constitutionality of what the Chief Justice has done. There you say the Attorney General is wrong. You believe to call it unconstitutional is wrong. Mr. Dave disagrees with you. Let's leave that aside. I want to come instead to a different point. As I said earlier, on Friday, Justice Kehar and that bench hearing the NJAC specifically asked the government to constitute the NJAC, and I'm quoting, as soon as possible, for the specific limited purpose of extending the tenure of existing additional judges. That was the reason why this meeting was called. Now, the Chief Justice, in refusing to attend the meeting, I put it to you, has undermined Justice Kehar and his bench. He's made a mockery of what they asked the government to do. And secondly, he's put himself in serious odds with his own Supreme Court. He's actually created enormous confusion by his behavior.
Karan, the point is this. The Chief Justice of India has felt that because the matter is pending, he does not want to attend a meeting while the validity is under question, for this very limited purpose to create the NJAC.
But what about his own court asking the government to constitute the thing?
That's what I'm telling you. That's what I'm saying. The court has required the constitution of an NJAC for a limited purpose of extending the tenure of the additional
But the Chief Justice has now scuppered
that. Now the Chief Justice of India,
Justice
of India's reaction to that, the Chief Justice of India's reaction to that is that I am not attending the meeting to call in the other, to decide the other
now as a result,
members.
The Chief Justice is at serious odds with his own Supreme Court. You're ignoring that point.
This decision of the Chief Justice was made before the conclusion of the hearings today. And I'm very interested in knowing what the Supreme Court said today on this score.
Probably nothing, because it hasn't emerged.
No, we have directed you.
Let me go back very quickly.
No, because we have directed you to attend the meeting. Did the Supreme Court say, Mr. Chief Justice, we have directed you to attend the meeting? What happened today?
Well, we don't know. We don't know. You're speculating, Mr. Sundaram. We don't know, so let's not go into speculation. I want to go very quickly to Mr. Dave. Mr. Dave, I've got limited time. I want to go to Mr. Dave. Mr. Dave, I want you to comment specifically, but briefly, because time is against us, very briefly, on the fact that the Chief Justice, in refusing to attend the meeting, has undermined and contradicted what a Supreme Court bench actually asked the government to do. He's put himself at odds with his own bench. Can you comment on that very quickly, literally in 15 seconds?
Can you repeat the question?
Mr. Dave, I'm sorry, we're running out of time. I can't repeat the question. I'm really sorry. I know we've got problems with the line, but basically I was saying the Chief Justice...
Let me say one thing, but...
Very quickly.
Let me say one thing, that it is settled of a Supreme Court that once an act has been brought into force, unless it is state, it has to be implemented by everybody, and that everybody would include the Chief Justice of India.
Absolutely, that's the answer to my question.
Unless
it's been state, the act has to be adhered to, the act is the law, and the Chief Justice has actually, in refusing to attend the meeting, put himself on the wrong side of the law. That is at least Dushyant Dave's opinion. R.M.S. Sundaram completely disagrees. Those are the two opinions. Now I leave it to the audience to decide whether the Chief Justice has acted properly or whether he's raised question marks about his behaviour and also put himself at odds with his own court.